this is a very important topic that we are going to deal with. I'll briefly introduce Dr. Neil Fernando to you, because some of the trainees who are new to our field do not know him. And Dr. Neil Fernando was the forensic psychiatrist, consultant forensic psychiatrist attached to the NIMH since 2003. And at that time, he was the only forensic psychiatrist for the whole country. And Dr. Neil Fernando has graduated from University of Peradeniya in 1979. And he became a consultant psychiatrist in the year 1986. And for a long period of time, he was a psychiatrist at the Provincial General Hospital, Badulla. And then he came to in 2003, he came to the NIMH Angoda. And since then, up until retirement in 2013, he was working there, mostly as the consultant forensic psychiatrist attached to NIMH. And he has been serving the country not only in the field of psychiatry, but in medical administration as well. He was the medical superintendent at General Hospital Badulla in 1990-1992, and then the regional director of health services in Badulla from 1992 to 1994. And then he became the director of mental health services attached to the Ministry of Health in 2002-03, and this for the second time in 2009. And also he has been the visiting consultant psychiatrist in the Sri Lanka Army from 1997 to 2011. So he has a vast knowledge in forensic psychiatry, and he has been a great communicator. He is a very well-known public figure who has the unique ability to explain very complex psychiatric issues in simple language to the layman. So thank you very much, sir, again for agreeing to do this important topic for us. And over to you, sir.
Yeah, thank you, Gihan. Thank you for your kind words. Good morning to everyone, and may I also wish each and everyone a very happy Christmas and also a happy New Year in 2021. Now, pardon me for starting with a negative aspect regarding forensic psychiatry. Over the last 2 years, the trainees who have passed the MD exam, none of them opted to do psychiatry when it was even offered. So this, I think, is a bit unfortunate because Sri Lanka has been training forensic psychiatrists over the past few years, and we have 3 very excellent forensic psychiatrists working at the moment in our country. And we are all proud of them, and it's unfortunate that forensic psychiatry has not been taken up by 2 consecutive batches which have passed out in the past 2 years. So probably the registrars who are now working with us and probably listening to this lecture, I think you need to think about it also, because this is a very good specialty that you can choose. One of the deterrent effect may be because you have to go to courts. And in my experience, I have been going to courts for forensic psychiatry for the past, I think, 17 years. And my experience is that it is a very pleasant experience, contrary to the common belief that that we all have. Simply because the courts need our assistance, and they actually treat you quite well, and they're always courteous and considerate, and I think it should not be a deterrent effect. On the other hand, it gives you an opportunity to actually share your knowledge and skills with another profession, the legal profession. And I think they are very grateful they will be very grateful to you if you come to their assistance. So with that kind remark, let me get on to the forensic psychiatry lecture or the presentation today. I am supposed to talk about the Sri Lankan aspects. So I will begin with this slide. You will be regarded as an evaluator, forensic evaluator. So all psychiatrists who are evaluating patients for forensic purposes, they will be termed a forensic evaluator. And there are certain important things that we need to be mindful of. One is that you need to be very truthful because you are now going before a court and you are giving. And it is very important that it has to be honest and truthful, which means you are saying you are telling only the truth. Yeah. And so that is one thing. Then also you have to be unbiased. That's very important because in a court of law, there are two parties, the prosecution as well as the defense, and you may be called to assist by any of the parties. It can be the prosecution or it can be the defense, but your role is you are treated as an expert witness. So your role is, whether you are called by the prosecution or the defense, is to give an unbiased, truthful opinion to the courts so that the courts can decide on the justice. You are not the person to decide. The courts is the one is going to decide, but they will, your opinion will be of great help and assistance to them. So it has to be an unbiased opinion, and also try to be objective as possible. Sometimes we may have to give our subjective opinion as well, but when you are giving that, then you have to state that. But always try to be objective. Then be simple and clear, very important, because you are speaking to a lay audience. Though they are a profession by itself, from a medical point of view, they are a lay audience. So you have to explain things in very simple and clear way so that they can understand it. And of course, you have to be factually correct with your clinical information. And also be logical in your expressing your opinion. Now, we will go into these things later. And of course, lastly, we have to work on time, because courts will give you certain time where you have to submit the reports. So it's very important that you have to work according to their time. So punctuality also becomes an important thing. So these are some of the expectations of a forensic evaluator if you want to do well in this field. Now, how does a forensic psychiatry evaluator differ from a general psychiatric evaluator? There are three things. One is that now in general psychiatry, we normally assess the present mental state. We are more interested in the present state of affairs. But when it comes to forensic psychiatry, we need to assess not only the present mental state. Present mental state, of course, is very important, but we need to also reconstruct the past mental state, especially with regard to an alleged offense. So that is something where you need a lot of skills and also a lot of information, because you are going to reconstruct the past mental state at the time of the alleged offense. The courts would want to know what was the accused or the defendant's mental state at the time of the alleged offense. So in order to do that, you need to reconstruct the mental state using whatever clinical information that is available to you. And you need to dig into this clinical information. We will go into the details later. And that is a very important part of work with a forensic psychiatry evaluator, which is not done generally in a normal general psychiatry setting. The third aspect is that not only you have to dig into the past, but also you may have to predict the future mental state, because the courts may want to know what will happen to this person when he is probably released to the community. Will he be violent again? Will he be aggressive? Is he safe to be discharged into the community? So there, the courts would want you the defendant's mental state to the future. So that's another aspect that we may have to deal when we are doing with forensic psychiatry evaluation. So that is something different from our normal day-to-day practice as a general psychiatrist. You can always interrupt me if you are not clear, or if you want any clarifications, or if you want to even share your ideas, you are most welcome. So please make use of this opportunity. I will also from time to time give you some time for you to clarify things if there is any clarification needed. Now, outline of today's program, I have thought I will just discuss two aspects which are important in our day-to-day practice in forensic work. The first one is the what we call the conceptual framework. I will explain what this is. And next, secondly, we will spend time applying the conceptual framework. So there will be a part where you will have to also take part. I will give you some case scenarios, and we will try to apply this conceptual framework so that you become more familiar in using it. So these are the two areas that I will cover during this 2-hour lecture. Now, starting with the first one, the conceptual framework. Now, what do you mean by conceptual framework? This is not something new to us, because we always work with a conceptual framework. Now, as a general psychiatrist, when you are assessing a patient, you have a conceptual framework. You start with the presenting complaint, then you go into the detail of the presenting complaint, then you look at the past history, past medical history, pre-morbid history, family social history, and then you do a mental state examination. Following that, you may do certain investigations, and then you come to a differential diagnosis, and then you plan a management. You plan the management. Now, that is also a framework, a conceptual framework which is useful in our normal day-to-day practice as a psychiatrist. Similarly, when you are doing forensic work, you need to have a conceptual framework so that you can organize all the different clinical information in a rational and a logical way, so that you can come to a conclusion. Because it is very important, at the end of the day, the courts wants our opinion. So to give an opinion, you need to organize your information, the relevant information, in a organized way. So to do that, this conceptual framework will be very useful. Now, this conceptual framework was put forward by a person called Rosner, and it has 4 steps. 4-step conceptual framework in forensic legal forensic psychiatry work. Now, what are the 4 steps? Let me explain it. The first step is what we call we have to first look at the issues. So when a person is referred to you, it can be a patient, it can be a normal person. When a person is referred to you, the first thing that you need to think is what are the what we call the psychiatric legal issues relevant to that particular person. Psychiatric legal issues. I will go into the details later. That's the first step. Now, the referrals can be from magistrate courts, high courts. Those are the 2 most commonly used referrals from the legal aspect. Then you might get referrals from the district courts. Also, you may get referrals from other medical specialists like the GMO or any other medical consultants, and the referral can be for a legal purpose. So whatever the source of the referral, the first thing that you have to look at is what are the psychiatric legal issues involved in that particular referral. That's the first thing. And I will go into details a bit later. So once you know the psychiatric legal issues, the second thing is to look at the legal criteria for each of the issues concerned. Legal criteria means how the legal framework to deal with these issues. So you need to know something about the law as well. And we will go into that also when we discuss it in detail. So once you know the legal criteria that can be applied to the psychiatric legal issues that is before you, then we have to find out what are the relevant data, which is the clinical information that will be useful to deal with this psychiatric legal issues. So the relevant data, which will be in the form of what we call clinical information, which is useful. And when we have all 3, then we will be able to come to an opinion through what we call a reasoning process. This reasoning process should be a logical process so that we not only give an opinion, we also give reasons for that opinion. Because in the court of law, you have to give an opinion, and that opinion can be questioned. And so you need to have the reasons for your opinion as well. So there is a very good way of reasoning out the opinion so that it will be very easy for you as well as for the courts to understand what you are saying. So we will go into these 4 areas in more detail now. Now the first one is the issue. What you have to ask yourself when a referral is made to you for forensic purposes, what is the specific psychiatric legal issue to be considered? That is the first question that you have to ask yourself in that particular patient or the referral. What is the specific psychiatric legal issue to be considered? Now, there is no such thing as a general forensic psychiatry examination. All forensic psychiatry examinations have to be based on a specific issue. So you have to start with the issue. There can be more than one issue in the same referral. Now, sometimes the court may request a specific psychiatric legal issue. For example, the courts may want to know whether this person is fit to plead in a court of law. Now, that is a specific psychiatric legal issue. If the courts make a request, then you have to address that issue. Sometimes the court may not ask for that specific issue may not be given in the referral letter or document. Then you are at liberty to ask from the referring party what is the exact psychiatric legal issue that they want us to address. You have the right to ask from the referring party. It can be the prosecution, it can be the defense, or it can be the judge himself or herself. So you can ask. So there is no problem in asking what the psychiatric legal issue is. Or the third way is you can assume all the relevant psychiatric legal issues and address them. And that is what we commonly do, because we get so many referrals so that we will not have time to ask each and every one from the referral party. So we assume from the information that we have, these may be the psychiatric legal issues that address them. And it is very important in the report that you write, at the beginning of the report itself, to state what you are actually addressing in that report. So it may be, as I said, more than one issue. Maybe it is about competence to stand trial or fitness to plead, as it is also said. Or it can be, in addition to that, there can be the psychiatric legal issue of criminal responsibility, right? It can be about a parental capacity, or the capacity to give evidence, that is called testimonial capacity, capacity to provide consent. So like that, there may be several issues. It's always good now if the issues are not specifically mentioned, then you have to assume the probable issues that may be involved and state them in the report. And it is good to state them at the beginning of the report so that the courts will know that what are the issues that are covered in your report. Now, these are some of the these are not the complete list, but these are some of the frequently used or addressed issues coming to a forensic psychiatrist or even a general psychiatrist. The commonest one, I would say, is the competence to stand trial, or what we call fitness to plead. So that is something that we commonly have to address. And also criminal responsibility. Both can go together most of the time. Both will go together. Criminal responsibility. We will go into those details later. Then maybe the issue of dangerousness. This is about predicting the future behavior. Then issue of testimonial capacity, that is the ability to give evidence in a court of law. Sometimes people may be referred, maybe a mentally retarded or intellectually disabled person. The courts may want to know whether the person is able to give evidence in a court of law. So that is called, the assessment of that is called testimonial capacity. Then you have what we call the testamentary capacity, that is about the ability to write a will. So there are certain criteria that you need to look at when deciding about the testamentary capacity. Then capacity to consent. Now again, it becomes an important issue, say in a sexual offense. This may be a very important issue, whether the person had the capacity to consent to a sexual relationship. So capacity to consent. Then child custody issues. When the parents are separated and when both parents are requesting the custody of a child. Now, courts would want to have a psychological opinion. Now, here the principle is the best interest of the child. So you look at from that aspect and then decide what is the best interest for the child with regard to child custody. Then sometimes you may be also asked about the capacity, the parental, what we call the parental capacity for to be a parent. So these are some of the issues, and now as you will see, now most of them are what we call civil courts issues, but the first 2, 3 are generally regarded as criminal issues. Now you know the courts, the legal system is divided into 2 broad areas, like in medicine we divide medicine and surgery. Like that there is a division, civil legal issues and criminal legal issues. So I thought I will today concentrate on the first 2 issues, which are the most commonly dealt with in a practicing psychiatrist. Competence to stand trial and criminal responsibility both come under criminal issues, but others are also important, and with the permission of Gihan, I may have to have another day to discuss the civil aspects, which are also important, and we will probably discuss it on another day. Right. Now, once the issues are sorted out, then we need to know what we call the legal criteria for each of these issues. So what are the legally defined terms and criteria that will be used for the resolution of the specific psychiatric legal issue? For example, if you are dealing with fitness to plead or competence to stand trial, then what are the principles or the defining terms to decide whether a person is fit to plead or not? So you need to know that. So you need to know the legal criteria for each of the specific psychiatric legal issue to be addressed. If you are addressing fitness to plead, then you must know the criteria that is pertinent or applicable to that issue. If you are addressing criminal responsibility, then you must know the legal criteria which is applicable to deciding criminal responsibility. So each psychiatric legal issue will have certain criteria. If you are thinking about consent, then there are certain criteria that you need to look at. So like that. So you need to know. So that's why you need to know a bit of the law which is being practiced in Sri Lanka in order to address that. Now, how can you find these criteria, especially the legal aspect of it? When it comes to criminal issues, the best place to go is to find it in the Penal Code of Sri Lanka, which is available in the internet. You can always download it and refer to it. And so that will give a lot of legal criteria with related to criminal issues. If you don't know, you can also ask the referral agent for the specific legal criteria. There is no harm in asking them. Or you can consult a lawyer whom you know, or you can ask from the referral agent directly to brief you on the legal criteria, because without knowing that, you may not be able to assess the person in the proper way. So this is very important. The second step in the conceptual framework, where you need to know about the relevant legal criteria for each of the psychiatric legal issue that you are going to address. Now, have that, then now we know the issue, we know the relevant legal criteria which is applicable to the issue. Now, based on those two information, then we can look at the clinical information available pertaining to the legal criteria used to the specific psychiatric legal. So what are the clinical information that you need? For example, if you are addressing the issue of fitness to plead or competence to stand trial, then it is about the present mental state that you are interested. So the clinical information has to be in relation to the present mental state. If you are addressing criminal responsibility issue, then you need to have clinical information related to the past, which is actually at the time of the alleged offense. What was the person's mental state? So obtaining data or clinical information, it can be with regard to the past, the present, and the future. And of course, the clinical data has to be relevant to the pertinent legal criteria. So without knowing the legal criteria, you may not be able to find the correct clinical information that needs to be looked at. So that's the third part of the framework. And the last part is, when you know all these three, then you go to the final part, which is what we call the reasoning process. How can the available relevant clinical data be applied to the legal criteria so as to yield a rationally convincing psychiatric legal opinion about the specific psychiatric legal issue? So, in other words, what we are saying is that you need to give an opinion about all these issues that are relevant in that particular person. And to give an opinion, that opinion also has to be a logical opinion, rational opinion. So again, there are one way of doing it is, the suggested way of doing it is to use this, what we call this 3-step process, so that it becomes logical. 3-step process. Now in the 3-step process, the first step is to state the legal criteria pertaining to the psychiatric legal issue, right? In the next slide, I will discuss an example. So the first step, you state the legal criteria pertaining to that particular psychiatric legal issue. That is a very straightforward, the legal criteria. In the second step, you have to state the factual position based on the clinical data available to you. The factual position with regard to that particular person. Then the third step is to come to an inference using the above two. So that ultimately your opinion will be based on a logical reasoning process. Now we will look at that as an example. The 3 steps. Application of the 3-step process. Now this is with regard to fitness to plead. Now what is the first step? Is to state the legal criteria. So that is what is given here under number 1. So the legal criteria is person who are competent to stand trial have the capacity to understand the charges against them, the capacity to understand the nature of the court proceedings against them, and also the capacity to cooperate with an attorney in their own defense. So that is the stated legal criteria. So you put that as the first. In the second step, you have to tell about your findings about the person. So in this example, a person named John Doe. So John Doe has the capacity. Now you have examined the person with regard to these capacities, and now you are putting the findings. John Doe has the capacity to understand the charges against him. He knows what he is being charged for. He also knows capacity to understand the nature of the court proceedings. He knows that he is being tried in a court of law, and he has a general understanding about what is being done, proceedings against him. And the capacity to cooperate with his attorney in his own defense. That's another important capacity that the person should have. The patient should be able to assist his attorney or the counsel or the lawyer in his own defense. So in the first step, we have laid down the criteria. In the second step, we have laid down the particular person or the patient's findings in relation to those 3 criteria. So the third logical step would be, therefore, based on these 2, therefore, John Doe is, in my opinion, competent to stand trial. So you give your opinion this way, so that the courts will then understand that you have come to this conclusion based on the legal criteria that they are going to apply, and you have applied it to that particular person. So that if you put like that, then it becomes very clear. And when you give a report like that, it is very unlikely that you will be called to give evidence also. So that also may be an advantage, because it is very clear. You can be called to give evidence by any party. The judge may want you to come, or the prosecution or the defense. But when you give a report like this, which is very clear, they will not have anything to ask, because everything is clearly stated. Of course, in the report, you need to highlight why you have come to this conclusion, but the conclusion itself is it has to be put in a very logical way. So this is what we call the 3-step process of reasoning, which I think it's a good way to actually handle legal matters. It makes things easy for you as well as easy for the courts. So I think I will give some time for you to clarify before we move on to the next part. Anything that you want to clarify up to now? Or any comments or any ideas that you want to share, please feel free to discuss.
Yes, have you got any questions to ask, Dr. Neil Fernando?
Otherwise, we can move on to the next part. Just to make sure for my own thing, did I make it clear to you or have I confused you now?
Very clear, sir.
Yes, it's clear, sir. Thank you, sir.
Okay. Right. Then, since there are no questions, so at the moment, we will then move on to the next part, which is the more important part, that is the application, the practical aspect. Application of the conceptual framework, the second part in my lecture. So this is the part that will take a longer time. Actually, what I thought was to discuss the two most commonly addressed issues, that is the competence to stand trial or fitness to plead and criminal responsibility evaluations, and try to apply this conceptual framework to those two issues. And so we will try to do that collectively during the next 1 hour, 1.5 hours. Right. So I will first start with this issue, what we call competence to stand trial. Now, that is the word, that is the term that is commonly used in the American legal system. The same thing in the British system is called fitness to plead. So we follow the British system, but so fitness to plead is something that is more familiar to us, but I think the other term is more accurate, competence. You are actually assessing or evaluating the competence or the capacity of the person to stand trial. Stand trial. Now, so this is one of the commonest evaluations that you have to make, and you don't have to be a forensic psychiatrist to evaluate this. All psychiatrists may be called upon to address this issue by a court of law. So if you are being sent a person, then you must be able to assess it and give your opinion. So we will look into details of this competence to stand trial, or called fitness to plead. Now, so I will use the word competence to stand trial because I prefer that term, but you can always use fitness to plead also. Competence to stand trial, or CST in short, represents the basic principle that defendants should have the ability to participate in their own trial. Now, you know, in a court of law, both parties, now there are two parties, no? The defendant and the prosecution, right? Prosecution is the aggrieved side, where the victim is. Now, in a court of law, in justice, both parties must be given equal opportunity. Now, competence to stand trial is an evaluation done on the defendant, only on the defendant. So if the courts request you to give an opinion on competence to stand trial, it will be always on a defendant. Defendant, another word for defendant is accused. The principle behind that is that that person should have a fair trial. And in order to have a fair trial, that person should be able to participate in the own trial. So participation is important. So what you are assessing is the ability to participate. That is the capacity that you are assessing. Ability to participate in their own trial. Now the Sinhala word, you may also have to know the Sinhala words because most of the courts in Sri Lanka function in Sinhala or in Tamil. If you go to Trincomalee, if you go to Vavuniya, if you go to Mana, Jaffna, courts language is Tamil. Of course, there will be translators helping you. But courts, normally it is the Sinhala. So these terms also are important to know, and competence to stand trial in Sinhala is Vitti Vachika Hakiya. Vitti Vachika Hakiya. So when you are giving evidence, if you know these terms, it is good because then the courts also will understand. Right. But always you can get assistance from the courts. If you don't know a term, Sinhala term, doesn't matter. You can use the English term, they will also write down, and they will also try to help you to find the Sinhala term, or they will write down the English term, but you may have to explain the term so that they will be able to understand it better. Right, so competence standards. So this is one of the, so in order for the defendant or the accused to have a fair trial, one of the legal principles is that the defendant should be able to participate in their own trial. Now that is why you may have noticed, if you have gone to courts, if the defendant is unable to attend courts for some reason, usually illness, the case is postponed, obviously. Because you cannot have a case heard without the defendant. But there is one exception. That is, sometimes the defendant is at large. The defendant is not available in the country, maybe hiding, not being able to found. So in a situation like that, you can have a case being heard without the defendant. That is a very rare thing. That is called the ex parte case hearing. And I had only one opportunity, that was in High Court Kandy very recently, where I had to give evidence where the defendant was not present. So in a way that is easy because there is no cross-examination, because there is no counsel for the defendant, and there is only one aspect, that is only the prosecution. So you have the prosecution and the judge to question you. In normally other cases, there is a defense counsel also looking after the interest of the defendants. So that was a case where the defendant had abused a child, and now he is absconding. So, but the case is going on. So I was asked to, because I had examined the child for that particular offense, and so I had to give evidence. Now that is a very rare situation. It's called the ex parte inquiry. But normally, the presence of the defendant is important, and it is only in his presence that a case is asked. Now, just having the defendant is not only important, the person should be able to participate in their own trial. Now, that is where the competence issue comes. So you have to assess whether the person has the capacity to participate in the trial. Now, in order to assess that, there are few things that you need to assess. First is there are 5 components that there are 5 components that you need to know when you are assessing competence to stand trial. So 2 important areas that you need to assess. One is the ability of the defendant to understand the judicial process. A very important assessment, or the capacity, ability of the defendant to understand the judicial process. I'll come to that in my next slide. Second thing that you have to assess is the ability of the defendant to assist their attorney in their own defense, cooperating and assisting with the attorney or the lawyer assigned to their own defense. Now, as you know, probably know, all defendants must have a lawyer to assist them. Now, generally, you have to find your own lawyer, but if you are unable to find your own lawyer due to financial constraints, then the court will appoint a lawyer. They will assign a lawyer to look after your interest. So that lawyer becomes your lawyer then. And the court will pay them the lawyer's fee, not you. That is when you are unable to find it. So it is very important that every defendant is assisted by a proper lawyer. Unless, of course, you decide to defend yourself. That is also possible. If you have some knowledge of law, you can say, I will defend myself. That is allowed. But otherwise, you will be always provided with a lawyer to assist you in your defense. Right. So these are the 2 abilities that we need to assess when we are assessing competence to stand trial. Ability of the defendant to understand the judicial process, ability of the defendant to assist their attorney in their own defense. Now, as I said earlier, competence to stand trial focus on the present ability. That is, the evaluation that you do has to focus on the current mental state. Evaluation focus is on the mental state at the time of the trial. Now, that's the important thing to remember. It is not the mental state at the time of the alleged offense. It is the current mental state. The person would have been of sound mind at the time of the offense. But if the person is of unsound mind at the time of the trial, because the trial may take a long time after the offense. It can be years after the alleged offense. So the person should be mentally fit. In simple terms, it is what is meant. The person should be mentally fit to participate in the trial at the time when the trial is held. So the focus is on the current mental state. In a way, it is easy because you are looking at the mental state that is present all the time. And we are, as psychiatrists, we are all trained to assess people's mental state. So it is not a difficult thing. Cst evaluation, that is competence to stand trial evaluations, examine a defendant's capacity to stand trial. Very, very important to note this word. What we are examining is the capacity of the defendant to stand trial, not their willingness to stand trial. Person sometimes will not want to stand trial, want to avoid going to courts, and might even mimic or simulate a mental illness in order to avoid going to trial. Now, that doesn't mean that the person doesn't have the capacity. So what is important, that is where you have to be careful. Cst evaluation examines the defendant's capacity, ability to stand trial, not their willingness. Cst standards requires only that the person have a reasonable degree of rational understanding. That is now the first, in the first ability that we are assessing is the ability of the defendant to understand the judicial process. Now this understanding is a reasonable understanding. That is any ordinary lay person's understanding. That is what is meant by that. Reasonable means that a normal lay person's ability to understand the judicial process. You don't have, that person need not have an absolute, perfect, complete capacity. I'll give an example. For example, if an accused is charged with murder, the reasonable understanding would be he should know that he's been charged for murder. Maawa mini marumakata tamai nadu dala thiyenne. And also must know how that murder has taken place. That is a reasonable understanding. The person does not know under what section of the penal code he is being charged. Now murder, the section dealing with murder is 295. So that is a perfect understanding. That is not required. If they know, just they know that he is ahavala maruwa kiyala. Ahavalata pihiyen ganala ahawal dawase. Natta ahawal wakawanuwe. Pihiyen ganala maruwa kiyala dannawana, that is enough. That is the reasonable degree of understanding. So when you are evaluating, you have to look for this reasonable degree, average person's knowledge, not an absolute, perfect or complete capacity. It's very important. Very few people will have that. Then the next important thing is presence of a mental disorder does not automatically make a defendant incapacity or incompetence to stand trial. IST means incompetent to stand trial. Just because you have a mental illness, it doesn't mean you are incompetent. So it is up to the evaluator to show the relationship of the mental disorder to the trial incompetence. If the person is incompetent, then you have to show that. Why this person is incompetent due to this mental disorder. For example, a simple example, a manic patient in a manic phase. They're very disturbed. So that person cannot behave in a court of law. Very disturbed. So that is the incapacity. So the person, you can say the person is incapable or the person is incompetent because the person is acutely disturbed due to his mental disorder diagnosed as a manic episode or bipolar with a manic phase. Right? But you have to show that. Just because now, for example, another good example is bipolar disorder. Now you know that bipolar disorder is an episodic illness. And most of the time the person are free of symptoms. In between episodes, the person is perfectly normal. So a trial may be occurring during between episodes where the person is perfectly normal. Though he has a diagnosis of bipolar disorder, he is still competent to stand trial. But if he develops an episode, a relapse during the trial, at the time of the trial or during the trial, then he might become incompetent to stand trial. So it is very important, this competency examination can be requested before trial, at the time of the trial, and also even before sentencing. Even after the trial, before sentencing, this can be asked because the person should be mentally fit in all these three: pre-trial, trial, and post-trial. Very important. So competence to stand trial requests can come at any time during the trial. Before the trial starts, during the trial, or even after the trial, before sentencing. And the request can be made by either the prosecution or the defense or even the judge. It can come from any source. So, to be competent, a defendant must possess the following. So these are some of the important clinical information that you need to know. The person has the mental capacity to appreciate his presence in relation to time. So the person should should be oriented in time, place, and person, know what is happening around him. Obviously, if the person is in a delirium, obviously the person does not have the capacity to stand trial because he is disoriented in time, place. So that's a very important area. Huh? Orientation in time, place, things person and people around. Then must also know that his elementary mental processes be such that he apprehends that he is in. Now he must also know that he is being charged with a particular offense in a particular court. So he must be able to appreciate that he is being charged in a particular offense in a particular court. And reasonable person would know that in a court you have a judge, you have a prosecutor who will try to prosecute him, and also a lawyer, a defense lawyer to defend him. The lawyer can be self-employed or court-appointed to defend him. That he will be expected to assist the lawyer in his defense. And some of the times, the court might also have a jury, which is a very rare phenomena because most of the accused prefer to hear the case without a jury. Now, in a criminal case in high courts, before the start of the case, the judge will ask the defendant whether he wants a jury trial or a trial without a jury. So it's up to you, and most of our accused prefer to have a trial without the jury because then it is the judge who decides. So most of them prefer the judge to decide because the jury comprises of lay people and they can be biased with media publicity and things like that. So generally, jury is not present in a high court, but when it is present, then the person should be aware of that also. And of course, has the memory sufficient to grasp these things. So the memory impairment also becomes an important issue here when you are looking at the competent issue. So these are some of the clinical information that you need to keep in mind, and areas to evaluate in a CST assessment. I think there are about 8 areas. Ability to work with the defense counsel, very important. He must cooperate with the defense counsel because the defense counsel cannot defend him without his assistance. So he needs to cooperate. Now, for example, problem area might be the defendant has a paranoia towards the defense counsel also. Because of the illness, he may have a paranoia towards the defense counsel also. So he looks at the defense counsel also as a person who is trying to harm him. So in a situation like that, he cannot assist. So obviously, then the person's ability or the capacity to assist the defense counsel is lost. So those are very important. Fine. Ability to appreciate his or her legal situation as a criminal defendant. They must know that they are being charged with a particular case, and so like that. So awareness about and understanding about the legal situation. Then ability to also understand the evidence that is being led, and ability to follow the evidence so that you know what is happening, because always he will be present in the courts and he will be listening to all the evidence that is given. Either some evidence may be on his behalf, some may be against him. So he must be able to follow them and understand. So ability, so for that you must have adequate memory and concentration power. Now, obviously a manic patient in an acute manic phase will not have the concentration power to do that, right? He will be very disturbed. And ability to maintain appropriate courtroom behavior. Now that's again very important. So restless people may not be fit to plead on that ground alone, because he cannot behave in a proper way in a courtroom. He may be shouting, screaming. So the behavior also needs to be. Now, I have found sometimes fallen into difficulty, because when we examine the patient at NIMH, the person is quite normal. I mean, it's a patient with a bipolar disorder, but now in remission. So I give my report saying that the person is fit to plead, competent to stand trial, because the behavior is also normal. But you know, in our system, there are some problems, right? So once the report is given, the patient has to be then taken to the from NIMH to the Valicada prison. Usually it's Valicada prison, and from there to the area prison. Say the patient may be from Anuradhapura. So then the patient is then sent to the Anuradhapura prison, and then to the courts in Anuradhapura. So this process might take at least 2-3 weeks sometime. And sometimes the medication may be discontinued. And by the time he arrives on the day of the trial at Anuradhapura, I have given saying that he is quite fit to plead, but the patient may have had a relapse. I mean, another common factor, precipitating factor, is sleep deprivation. Right? You know, in courts, in our remands and prisons, the conditions are not very good. So even the sleep may be inadequate, and that can precipitate. On top of that, when you are without medication also. All these things can precipitate. Sometimes the courts again might then ask you to re-evaluate. So you need to actually then acknowledge that. So it is always good to tell in the report that the person needs to be continually on a medication that is being given. Otherwise, you can always, for your safeguard, say that discontinuation of the medication and deprivation of sleep might precipitate a relapse. So you can always state that, because it has happened to me several times. So you need to be mindful of that as well. So these are the things that we tend to assess in a person who is being sent to us to assess the competence to stand trial. Right. Now I think we will spend some time reading this case details. So I will give you, what I want you is to read this. Can you see the screen clearly?
Yes, sir, we can see.
Right. So then what I want you to do is read it carefully, even several times, and then just give you a reasoning process. That is your opinion. In that 3 steps, so what you have to do is, after reading this, write down the 3 steps that you would write to give your opinion regarding this person's competence to stand trial. I am only asking about the competence to stand trial, right? Not criminal responsibility, just competence to stand trial. So you state the legal criteria, that's the first statement. Then the criteria related to this patient. And then third step is the opinion, right? So I will give you, say 10 minutes to write it, and then we can discuss it before we go further. So take about 10 minutes. So it's now the time is 11:14, say it's 11:50, right? So I will give you time till 11:25. So 10 minutes to write it. So I want the registrars to do this actually. Others also can do if they are interested. And we can then discuss. Okay, can we have some feedback? Any volunteers? I want you to give the 3-step process, right? The first, so I need the 3 sentences in relation to this case. So what is the first sentence? That is easy. That is just to state the legal criteria. So anyone, yes.
So this is Isuri.
Yes.
So as to the
first sentence.
first sentence, the legal criteria of the specific psychiatry legal issue of fitness to plead.
Yeah. What I want is the exact wording of that sentence. What you are going to write in the report, right?
Yes, sir. So the legal criteria
Yes.
for fitness to plead would be
describe it. Yes.
Nature of the charge against the defendant, the nature of ability to understand the nature of the court proceedings, ability to cooperate with. Sorry, sir.
Read it from the beginning again.
Yes,
Can
sir.
you read it from the beginning again? The first
Yes, sir. So the legal criteria for fitness to plead would be the ability to understand the nature of the charge against him, the ability to understand the nature of the court proceedings, the ability to cooperate with his attorney, the ability to challenge the jurors, and the ability to follow the evidence.
Okay, right. So you write the first, yes. What will be the second? Yeah, that's okay. That's okay. So what will be the second sentence then?
And the clinical information I have gathered from assessment of the defendant's mental status would be that although Mr. C is able to, he has the ability to understand the nature of the charge against him, he is incapable of understanding the nature of the court proceedings. He doesn't have the ability to cooperate with the attorney, and he would not be able to follow the evidence at the court.
Yeah,
therefore, my conclusion would be, as of the time of the assessment, that Mr. C doesn't have the fitness to plead.
Yeah, he is not fit to plead. Yes.
He's not fit to plead, sir.
Yeah, good, very good. Yeah, that's okay. So it's not very complicated thing. It's just to what you are doing is actually you are organizing your information in a clinical, in a rational way and logically putting it across so that people who read the report will understand what is the opinion and how you have come to that opinion. So both things are in your answer, both things are there. So that's good. So now my answer, in the next slide, I will give the answer. I mean, there is no one way of answering. So this, what Isuri said was acceptable and correct. And so this is another way of putting it. Persons who are, so the first sentence would read like this: persons who are competent to stand trial have the capacity to understand the charges against them, the capacity to understand the nature of the court proceedings against them, and the capacity to cooperate with an attorney in their own defense. Then you state the factual things that you have gathered from the case history. Mr. C does not have the capacity to understand the charges against. Now you said he knows the charges, yes, but he knows the charge, but he doesn't understand that he's been charged, because that is what he's, in the case history, he says that nothing will come to me, I will be released and things like that. So obviously he doesn't understand the charge, but he knows that he's been charged in court. So knowing and understanding are two things, but that's a minor thing, that's okay. So does not have the capacity to understand the charges against him, does not have the capacity to understand the nature of the court proceedings against him, and does not have the capacity to cooperate with his attorney in his own defense. Therefore, in my opinion, Mr. C is not competent to stand trial, or you can say not fit to plead. So that is how you need to give your opinion with regard to competence to stand trial. So good. So we will not have time to discuss any other answer. We will go to the next issue, that is the next important issue is on criminal responsibility. Criminal responsibility. Now, that's the other commonest issue that we need to deal with in our normal day-to-day psychiatric practice related to medical legal issues. Now, criminal responsibility evaluation is also called insanity defense. So that is in the legal term, it is called insanity defense. Now here insanity is a legal term. Please understand that it is not a medical term. It is insanity from a legal aspect. Legally insane are two things, right? So this is insanity is a legal term. Determines whether, now what criminal responsibility evaluation is, to determine whether the defendant is so mentally disordered that he or she is not blameworthy or criminally responsible for his or her behavior. So in other words, what we are saying is that the person is so mentally ill and disordered that it is unfair for him to be blamed or held responsible for his behavior, because he is ill and his behavior was a result of his illness. That is what we are saying. So to do that, we need to have a retrospective evaluation. Now, this is very important. Retrospective evaluation of a defendant's past mental state, functioning, and capacity at the time of the alleged offense. Now, that's the tricky thing. At the time of the alleged offense, what was his behavior? What was his mental state? What was his functioning? What was his capacity? That is what we have to assess. So in order to do that, you have to reconstruct the mental state from the available clinical information. So you have to gather information which will give light to the defendant's past mental state, and that depends on when you see the defendant. Sometimes it can be soon after an offense, then you are lucky, then it is easy. But sometimes you see the defendant long time after the alleged offense. Then you have to really go into the detail. You need a lot of information in order to come to a conclusion. If you are unable to come to a conclusion, you can state that in the report. For example, now recently I was asked to give evidence in Mana, High Court Mana, and in my report I have stated that I am unable to give an opinion about the criminal responsibility because, so you must give the reasons, because the request for the police B report, which I will describe later, was not available for me at the time of the assessment. So when I gave evidence, I stated that it was in the report, and that was it. Then the judge asked me in the courthouse whether if the judge gives the police report now, whether I can again go through it and give my evaluation. And I said yes. So the judge immediately took steps to actually provide the police reports and gave another date for me. Only thing I have to again go to Mana with that information, right? So these are very important things. And the courts are also very helpful in that way. So if you are unable to state the evaluation, or if you don't have the adequate clinical information to come to that conclusion, better to mention it, or you can mention it as a limitation. Right. So because you need a lot of reports, a lot of information in order to reconstruct the mental state. Now, the legal side for that is in the penal code. Criminal responsibility evaluation, the legal criteria is in our penal code. Now, the penal code can be downloaded through the internet. It is in chapter 4. There is a chapter 4 is about general exceptions, general excuses or exceptions, and section 77 of the penal code deals with this particular area of criminal responsibility evaluation. Now, you must know the background for this law, which is also called the Mcnaughton law, the Mcnaughton rule, dates back to 1843, long time ago. And some idea about Mcnaughton also you need to know. Now, Mcnaughton, he is the person you can see in the screen on your right side, top picture is Daniel Mcnaughton. Now, he was a patient diagnosed with schizophrenia, and he had a paranoid delusion thinking that the government at that time, the British, now he was a Scottish person, and he thought that the government, UK government, was actually planning to kill him. Due to his paranoid state, he had that delusion. So he thought that this is going to happen, and the only way to avoid this is to kill the head of the government, which is the Prime Minister. So the Prime Minister at that time was Sir Robert Peel. You can see it in the other picture, Prime Minister of UK. So what he did was he actually took a gun and he actually went and shot the Prime Minister. The bullet did not hit the Prime Minister, but hit the secretary of the Prime Minister who was next to him. That person's name is Edward Drummond, and he actually died as a result of the bullet injury. So anyway, at the trial, you can see in the bottom picture, the trial itself, the picture of the trial, Mcnaughton trial, he was acquitted. He was found not guilty because of the reason of insanity. And that actually led to a big outcry, and also especially the Queen. At that time was Queen Victoria. She got very angry over this acquittal, and she ordered the law lords, they call the law lords, to actually define a law in relation to criminal responsibility. And that is how this law came into being. And that law was called Mcnaughton law or Mcnaughton rule. But actually Mcnaughton was not tried in using that law, but it was after his trial that this rule came. And that rule is the thing that is still we use. So now this is the Mcnaughton rule. You can always look at it. I'm not going to go into details of it, but what is important is what we are using now in our codes, in our penal code, is a modification of the Mcnaughton rule. So the modification, this is what we are using, and that this you must know. Now this is the section 77 of the penal code. It says it's a modified Mcnaughton standard, more or less the same, but a few words are different. Nothing is an offense which is done by a person at the time of doing it by reason of unsound. Now the word is unsoundness of mind. The original word was mental disease of the mind. Defect of reason from disease of the mind. That was the original version. Now in our penal code, we have unsoundness of mind. In Indian penal code also it's the same word, unsoundness of mind, and is incapable of knowing the nature of the act or he is doing what is either wrong or contrary to law. So, unsoundness. So, in the singular word for unsoundness is sihi vikalatve. That is what the legal term in Sinhala, sihi vikalatve. So, if you say sihi vikalatve peluna, that means legally it is understood as unsoundness of mind. So, these words are also important when you have to give evidence, especially you write your reports in English, but when you have to give evidence, you have to give it in Sinhala. So knowing the Sinhala words are also useful. Right, now, so using the law, legal definition of insanity has two main features. The first one is there is a reference to mental disease or defect. In our law, it's called unsoundness of mind. So that is one aspect. So there should be a mental illness or a defect. To be unsound, you must have a mental illness or a defect. Then the second part is the description of a specific incapacities. The person is, as a result of this illness, they are incapacitated. Two incapacities. One is cognitive incapacity, other one is volitional incapacity. Cognitive means your thinking is reasoning, understanding, comprehension, that is impaired. And other the volitional. Volitional is the behavior. And that is about behavior or behavioral control is impaired. Now, normally unsoundness of mind in court of law includes in severely abnormal mental condition. Not that every mental condition, mental disease qualifies to this law. Generally, it is taken as severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality. So that is what you have to look at. Whether the person's perception and understanding of reality is lost. And for example, psychotic illnesses generally are accepted to qualify to this situation. So that is why the diagnosis also becomes important. Not that the diagnosis is important for the law, but the diagnosis is important to imply that that illness is a severe mental disorder. So all psychotic disorders generally will fall into that category. Then depressive disorders, patients with severe depression. Bipolar disorder, right? During a relapse, right? Not during remission, during relapse. Then delirium tremens, right? Now that is an alcohol withdrawal state. I will come to that also. Alcohol intoxication. Intoxication I will deal after this thing. So delirium tremens is another defense. Now I had an opportunity of actually defending. It was a rather interesting patient. He was from Tangalla and he entered the Tangalla hospital for fever. And he was an alcohol dependent person and he did not reveal his alcohol history, nor the medical people asked about that history. So it was unknown to them that he was a dependent drinker. And I think it was the next night, not the same day, the next night. So it's about 48 hours after admission, he developed a full-blown delirium tremens. He went into delirium tremens, acute confusional state, middle of the night, around 10:30, 11, jumped out of the hospital, jumped out of the ward, jumped out of the hospital and ran along the road. Now, this road is, Tangalla, Hambantota road. So he ran towards Hambantota side, right? So hospital is in a hilly area and he ran down the road and then he suddenly saw, this is around 11 in the night, he saw a parapet wall and he climbed the parapet wall and then jumped inside the premises. And as soon as he jumped into the premises, there was firing from all sides. gunfire because he had actually jumped into, at that time, President Rajapaksa's personal, his own house at Tangal, Carlton House. And the security there had started firing. But fortunately, he was so disturbed that none of the shots hit him. But ultimately, he was caught, and then, of course, he was produced in our ward. So I had to go to courts to defend. Now, he had actually, the offense was that trespassing the president's house. Of course, the president was not there at that time. But anyway, the charge was very serious. So I had to go to courts and explain why he behaved like this. So delirium tremens is accepted, and the courts actually accepted and actually released him. So delirium tremens can be used. Then other thing is, of course, PTSD, severe form of PTSD. Now, these are some of the conditions. It doesn't mean that these are the only conditions, but it needs to be severe conditions to impair the person's perception, understanding of reality. Yeah? And also it is necessary to demonstrate how the disorder was of such severity as to impair the defendant's ability to rationally perceive or understand the circumstances the alleged offense or to make rational choices. In other words, what it says is that you have to show why the illness was of such severity and how his or her ability to perceive things in a rational way was lost due to the illness. That is what you have to show in your report. Now, I said there are two incapacities. Now, one is what we call this cognitive incapacities. They are also called prone. So, assessment of the defendant's capacity to recognize that the alleged behavior is wrong. So, the person capacity to recognize that the behavior is wrong. Now, due to the illness, sometimes the person may not recognize that the behavior is wrong. Now, for example, in that patient with delirium, the person was confused. He did not know where he was, what he was doing, and to which house he had jumped. He had absolutely no clue. He came to his senses only in the remand prison. So his capacity to recognize the alleged behavior was not there. So there are two types of wrong. Legally wrong, that is the defendant know it was against the law, and moral wrongness, contrary to individuals and society moral standard. Now, a lot of times we will get patients who know that the behavior is wrong, but think that they are morally justified in behaving in that particular way due to the illness. So that is very important to remember. So that's why I said instances will occur where the psychopathology is such that he retains the knowledge that the behavior would result in legal sanctions. So in other words, he knows that his behavior is wrong, will lead to legal sanctions, but is convinced that the behavior is morally justified. Behavior is morally justified. For example, a person acting at the commands of a hallucination. Now, he knows what he is doing is something wrong, but he feels compelled to act on the command because so he feels that he is doing what is being told to do. So that is the moral wrong. And so most of the time you will have this situation where you need to explain why the person was incapacitated. It is usually the moral wrong that we need to highlight most of the time. The second part is the volitional incapacity, that is the behavioral part. And there are 5 criteria to actually look at that, which is not very often we don't use this, but it is also good to know about it. capacity to make choices, whether the person had the capacity for an alternative behavior. Instead of doing the offensive behavior, was there a capacity for alternative behavior? Did he have the capacity? Capacity to stop the behavior or delay the behavior. Regard for apprehension. What did he do when the police was trying to catch him? Did he go and hide? Action to avoid detection and things like that. All these are important things when you are calculating the capacity of the person's knowledge about wrongness. Prior experience, whether the person has experienced similar experience before. Now, this becomes again an important issue when we discuss intoxication, which I will do in a few minutes. Prior experience of volition is very important. And also, obviously, all this have to be a result of a mental disorder. So at the end of the day, we have to first find whether there is a mental disorder. So relevant clinical information, now you have to, because you have to reconstruct the mental state, you need a lot of clinical information, collateral records, responsibility. Now these are some of the things that we go for. Defendant's account of alleged crime to the police. Defendant's own statement to the police. Now, how can you get that? You have to ask for what we call this police B report. It is called the B report. Don't ask me why it is called B. I don't know. There may be a reason for that. But it is generally called the B report. Now, what is the B report? B report is the report that you send, the police send to the magistrate. That is called the B report. That is about the progress of the investigation. First, in the first B report, they have to say that such and such a criminal offense has taken place at a particular. So you mentioned, they mention the date, time, and the persons involved and things like that. And then from time to time, they have to send a B report stating the progress of the investigation. So that is called the B report. So usually you have several B reports. And in these if you read these B reports, you get an account of what the defendant was thinking and doing at the time of the alleged crime. So it gives you insight into the crime. So it's a very useful report. And our police are kind enough to actually give it. Sometimes they read it over the telephone. If the police station is very far, sometimes we get them to read the B report and we write it down. Registrars, generally, they write it down over the phone. That's okay. But sometimes we ask for the B reports, and sometimes through the courts we ask, and sometimes it is given. So if you have, then it is good. Then victim and witness statements. Again, police will investigate and take statements from the victim, if the victim is alive, and any other witnesses. And all those things will also give you insight about the mental state of the person. Then if you are lucky enough, videotape of a crime or crime scene. Sometimes that may be available and that may be very revealing, very important. Then records of crime scene visits. Now that is what we normally do from time to time when we need to get more information. We do what we call a crime scene visit. And most of the time the registrars go for these visits along with the psychiatric social worker and the area police. Always get the assistance of the area police. And these crime scene visits are very revealing. I can give you an example where one patient told us that he has killed a person who came to his house. Now he was living in Bandaravela and he was living alone in that house. And one day a visitor had come and he had killed him. And then of course he was arrested and he was sent to our ward. And where he said that he had this delusion that the army camp, now he was in Bandaravela and overlooking the Diatalav army camp. this was during the wartime days, he thought that the army camp is actually planning to send a mortar attack to his house. So he had this belief. And as a result of that, he said in order to protect himself, he had built a bunker inside his house. This is what he told us. He had built a bunker inside his house. But this is what he said. But how do we know whether this is true or not? So we did a scene of crime visit. So I got one of the registrars working with me at that time to go with the psychiatric social work and the local police. And they went and visited the house. They went inside the house and there was a bunker. And it was a complete bunker, concrete bunker. Outside the house is normal. Inside, it is completely, it's a bunker. All the windows were sealed and it was, so it was very revealing. So obviously the delusion was correct. So he had the delusion and that is why he was living in that. And when this visitor came, he thought that this was an army spy who had come to visit him. So that is why he killed him. So like that. So crime scene visits, when will give you a lot of information. Then prior psychiatric records, again, very important to find out psychiatric records from other hospitals, right? So normally you have to write to the units and get the reports. So that's another important area that will also indicate about past illnesses. Then prior medical records and various other records, which are important. And now, of course, we have the computer and the communicating resources using the internet. There was a case where the courts wanted us to decide whether this was a suicide or a homicide. And one of the things that we looked at was the communication, the internet, the computer, and the mobile phone. We got the police to download the communications and they gave it us, and it was very clear by going through it, it was a clear suicide. So like that, so the computer and community, those are also now becoming important in our gathering of clinical material. Right. These are some of the important things too, that if you know, it will help you to decide whether the person knew what he was doing was wrong. Evidence that may indicate a defendant's knowledge of legal wrongfulness. So, efforts to avoid detection. Were there any action taken to avoid detection, like wearing gloves during a crime? All these information from the police reports, police investigations, you can find out. So when you read a report, you must know what to look for. So our intention is to find out whether the person knew what he was doing. Was this a planned act? Now wearing gloves during a crime, so that shows that the person has been planning it. Waiting until the cover of darkness. Taking the victim to an isolated place so that no one can see the crime. Wearing a mask or disguise. Concealing a weapon on the way to a crime. How did the person take the weapon on the way to the crime? Falsifying documents. Giving false names. Threatening to kill witnesses. Giving a false alibi, that is an explanation. So things like that will indicate that the person had the knowledge that what he was doing was wrong. But still, it can be morally justified. That also we have to remember. Then disposing of evidence, still in the same thing. For example, wiping off fingerprints, washing off blood, discarding a murder weapon, throwing the murder weapon or the knife or the weapon to the river or whatever, discarding, hiding it or hiding it. Burying a victim secretly, destroying incriminating documents. And lastly, you have behaviors to avoid apprehension, fleeing from the scene, fleeing from police, lying to the police and things like that. All this together, not one piece of evidence, all evidence together, if you can collect, that will indicate the mental state of the person at the time of the alleged offense. Right. So, shall we read this again? And again, what I want is the three-step process. Now, this is with regard to criminal responsibility. Yeah? Only think about the criminal responsibility. So read it and then formulate your opinion using those three steps. 1, 2, 3. With regard to criminal responsibility. Gihan, are you there? Can we have some more time? Or have we got to stop at 12 or can we go a few minutes beyond 12?
No, so I think it's all right. There's no hard and fast rule that we should stop at 12.
Right. So because we need to give the registrar some time to
that's okay.
This, yes, that will be easy. Yeah. Anyone who has finished can come out with the formulation. Just the 3 sentences. Answer is obvious, but how you put it is the important thing. How you communicate your opinion in a logical way. That is what you have to practice actually. I will give you another 1 minute.
Yes, I think somebody wants to give the answer, but I think if you unmute yourself, you will be heard.
Yeah, just unmute and speak. Yes. Ken. Who is speaking?
Hello, sir. This is Jayanta here.
Right. Good. Go ahead.
Now, legal criteria for in this case is
Yes.
the criminal responsibility in the psychiatrist terms, mental state at the time of the alleged incident.
Yes. So, what do you write in the first statement? What is the first statement?
Now, criminal responsibility states that nothing is an offense done
Yes.
by the reason of unsoundness of mind.
Yes.
And incapable of knowing the nature of that and knowing that's wrong morally and legally.
Yes. Yes.
In this case,
so that is the first sentence, no? Yes.
Yes.
So then you go into the second sentence, which is related to the present problem. Huh? Yes.
Yes.
So what is the second sentence?
In this patient's incident,
yes. So you can call Mrs. G. Mrs. G, yeah. No? Yes,
Mrs.
the name.
G
you already address by the name, right? Mrs. G, yeah. Or you can say the defendant. You can use anyone. But this is a more better way, right? Telling the name. Yes.
Mrs. G knows the nature of that, but still unable to understand that is wrong morally.
Yes.
Therefore, patient does not have has not been in clear soundness of mind and does not possess the criminal responsibility. Of course, the criminal responsibility is to be decided by the court. But
but what you are giving is an opinion.
Yes.
What you are giving is an opinion which can be accepted by courts or it can be not accepted. That's up to them. But we can give the opinion and the reasons. So your third sentence is therefore Mrs. G is of unsound mind. No,
unsound mind. Yes.
Yes, unsound mind.
Yes.
Yeah. So I think it's quite good. Quite good with given the short time. Yes. So it would be like this. Now, what you say is the same thing that I have also written. Let's skip that. Yes. Yeah. So nothing is an offense. So this is the first step. What you read now, nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is in. Now we have to use the word unsoundness of mind. That is what the penal code in Sri Lanka says. is incapable of knowing the nature of the act or that she is doing what is either wrong or contrary to the law. You just state what the law says. Then second sentence is related to this case, right? Mrs. G. Now this is one way of putting it, right? The same thing what you said in a different way. Mrs. G demonstrated acute symptoms of a mental illness diagnosed as schizophrenia at the time of the alleged offense and did not have the capacity to know what she did was wrong, as she, due to her distorted thinking, was convinced her behavior was morally justified. Morally justified. So within bracket I have said moral wrong, but that need not be written there. Justified. Therefore, in my opinion, Mrs. G was of unsound mind at the time of the alleged offense. You understand? So when you tell that, when you give this opinion, then it becomes very clear what is your opinion and how you came to that opinion. So it talks about the mental illness, it talks about how the mental illness affected the behavior. We talk about the distorted thinking, the moral justification, things like that. Everything is included in these 3 sentences. So it becomes very clear. And then the courts also will find it very difficult, very easy to understand what you're actually communicating. So this is one way of doing it. Of course, wording need not be always exactly the way that I have written. It can be your own way, and what you said, Jayanta, is acceptable, quite good. So that is okay. You have your own way of communicating. That's okay. You can use your own way, provided you stick to the basic principles of these 3 sentences, right? Now, the slide before this, I didn't discuss, but now it is actually the same thing. First thing that you have to demonstrate is that the person was mentally ill at the time of the alleged offense. That has to be established. So that's why I said in this thing, Mrs. G demonstrated acute symptoms of a mental illness. And I named the illness also to indicate that it's a serious illness, diagnosed as schizophrenia at the time of the alleged offense. So that's the first thing. Then the second thing is about the incapacities. Second and the third thing is about the incapacities, behavioral incapacities and the cognitive incapacities. So that is what is stated in the next part, and did not have the capacity to know what she did was wrong, as which was why did she not have the capacity? Because she was her thinking was distorted, and she was convinced that what she was doing is morally justified. Therefore, she was of unsound mind at the time of the alleged offense. So that is how you have to do it. Now, sometimes you might have a situation where intoxication might also come into the picture. So then you have to also mention about that, the role of the intoxication. I will only spend another 5 minutes just to talk about this intoxication, because it is also commonly associated. So the role of intoxication, which is also closely associated with criminal offenses. So what is if the person comes with a history of intoxication, usually alcohol, it can be other intoxication also. You must know some basic things, just one slide on that. What you need to know, right? Now, these I will not go into details, but it is self-explanatory. Voluntary intoxication is not considered as a defense of insanity, right? You can't drink on your own and then say I was drunk and seek excuse for that, right? Voluntary intoxication is not considered as a defense of insanity. But there are some other situations where alcohol may be used, even drinking alcohol or any other drug can be used as a defense. Now, for example, cumulative effects of intoxication. Please understand the word cumulative effect. That is, if you have been drinking for a long period, is considered as a defense of insanity. For example, alcohol-induced dementia or Korsakoff psychosis. Why? What is the reason? You must know the reason, and then you must explain that reason also in the report. Reason is effects lasting past the period of intoxication. Right? These effects are fairly stable, permanent effects which last beyond the intoxication. Even if the person is not intoxicated, still the effects of dementia and Korsakoff psychosis may be there at the time of the alleged offense, though the person was not intoxicated at that time. So that can be used as a defense. So, but you must explain it. Then substance-induced psychotic disorder. For example, this or LSD, just this is a hallucinogenic drug. You can have behavior disturbances, is considered as a defense of insanity. Why? Reason is its effects continues past the period of intoxication. What they look at is that was the person intoxicated at that particular time of the alleged offense. If it is beyond the normal intoxication period, then you can use it as a defense. So these things you may have to argue, and so then withdrawal effects, which I have already described, like delirium tremens, is considered as a defense of insanity. Now I said, no, I defended that person. Why? Because reason is withdrawal effects or the delirium tremens is the behavior is not due to the intoxication, but because of cessation of intoxication. That's why it is called withdrawal. So that is allowed. Then involuntary intoxication, where a person may not know that the person is taking a drink, and it may be someone has added alcohol without the person's knowledge. It's unknown. Or sometimes persons can behave abnormally after a prescribed medication. We know sometimes medications can induce a acute psychotic state or acute disturbance. So considered as a defense of insanity because there is no personal responsibility there. Then pathological intoxication, which is again a rare situation, is considered as a defense of insanity. Reason is that it is an idiosyncratic reaction. But it can be used only on the first occasion. You can't repeatedly use that as a defense because the law says that you must understand that drinking alcohol, now these common use is alcohol pathological intoxication. If you know that if you drink alcohol and you get disturbed, then it's up to you to not drink. So on the first instance, yes, you can use it as a defense. So that's just the role of the intoxication. So what you have to do is, if there is a indication of intoxication, you have to see whether it is acute intoxication, whether it has a cumulative effect, whether it is a substance-induced psychotic sting, withdrawal state, or whether it is involuntary or pathological. Those are the areas that you need to look at. Then lastly, this is the last slide, extreme emotional disturbance. Sometimes patients may go into an extreme emotional disturbance, maybe an acute stress reaction, and may commit a criminal offense. So in that situation, what the psychiatrist's role is to describe the defendant's mental condition, how it impacted his behavioral control, and what the person was thinking and acting. Just describe it, but don't give an opinion, because the legal standard is whether the defendant's behavior can be reasonably explained. Whether it can be reasonably explained, that is left to the judge to decide. You don't have to decide on that. You are not an expert to decide on that. What you can say is how the behavior occurred and what was the mental state and how it affected the behavior and his thinking. Let them decide whether it is a reasonably explained behavior or not. That's up to the courts to decide. So you don't have to give an opinion. So I will stop there. So it's about 2 hours and 15 minutes. Are there any questions or anything that you would like to? If you need these slides, how can I give it to you? Gihan,
so if you,
yeah.
So if you can email it to me,
right.
I can circulate among the trainees.
I have your email, no? I think you have.
Yes, yeah.
I will do that. I will do that so that they can have it as a reference, right? Okay.
Thank you very much.
Any other questions? Wanted to?
Yes, sir. Actually, I have 2 questions. I don't know whether because of the we are pressed for time. First, I would like to thank you, sir, for that very descriptive presentation. My first question is, from an exam point of view, in the MCQ exam, if we are asked, if we are given a statement just to choose between true or false, a statement saying that Sri Lanka Section 77 of criminal responsibility, Section 77 does not consider volitional prong in deciding criminal responsibility. We should consider it as true or false.
Yes, if you are given that, then now there is no other choice. Now you have to answer it. And things. So then, yeah, you have to, what you said. The answer is the answer. Yes.
So is it like
functional side? Yes. Yeah, but when it comes to practical terms,
yes, sir.
Courts actually ask this question: whether the person had the control over his behavior, right? And then you can actually, so it's better for in your report writing or when you are gathering information, look at all those and mention it. So that will strengthen your argument, and that will be assistance to the courts also.
Okay, sir. Thank you, sir. The other question is about the pathological intoxication, sir.
Yes.
When you said that it is considered only for the first time as a defense, does that mean the first ever in time the person got pathological intoxication, or the first ever time the person was convicted of an offense, but he has past history of pathological intoxication?
Yes. Now the prosecution will try to find out information which will indicate that he has been behaving similar way earlier also, though it has not led to legal things. But if the prosecution can show that evidence convincingly, then you will be not allowed to, so the defense will not be allowed to, actually defense argument will not stand, because the person has had this experience before also. So the judge will then take that also into account.
Okay, sir.
So it is, so, but it's up to the prosecution to find out.
Okay, sir. Thank you very much, sir.
Yes.
Thanks a lot, sir. That was very descriptive.
Any other questions? Okay, then Gihan, can we call it?
Yeah. Okay, then sir, let me take this opportunity to express our sincere gratitude on behalf of the Sri Lanka College of Psychiatrists for accepting our invitation and doing this lecture for us. It was very informative, and we already getting calls from trainees as well as from practicing psychiatrists to say that it was very good, and not only for the trainees, that it was quite refreshing and informative, and also thought-provoking for practicing psychiatrists also like us. And I think it's really practically useful in preparing reports and defending our mentally ill clients. So thank you very much, sir, for that very informative, very descriptive, and a very interesting lecture. And now,
Gihan, we will arrange the other part. The civil side is also fairly important for practicing doctors. We will have it on another day that is convenient to all of you. You can actually decide on the day and tell me. So I will.
Yes. So now, what the trainees and the other psychiatrists want is if you can have it just after this, so that we will be fresh in with the knowledge given by you. Now we have 2 more lectures in January, sir. On the 9th of January, we are going to have Dr. E.K. Rodrigo and Dr. Jan Mendis talking to us on the development of community psychiatric services in Sri Lanka, the Western models of community psychiatry and their applicability to Sri Lanka. And on the 30th of January, Professor Nalaka Mendis is going to talk to us on development of a comprehensive approach to mental health services in Sri Lanka, challenges facing the profession.
Right.
So, and if you can do it before is it possible to do it before the 9th of January on the 2nd of, on the 2nd of January, Saturday?
Saturday, same time, is it?
Yes, yeah.
Yeah, okay, I can do that.
Okay, so then we'll do it on the 2nd of January, and the topic
coming Saturday.
Yeah, and the topic will be
the same topic, the extension of it will be on the side, right? The civilian law.
Okay, okay.
Okay. Okay, thank you very much.
Thank you very much for that, and we'll hopefully see you next Saturday at the same time from 10 to 12.
Yes.
And thank you very much, Chamara and Sumudu, for coordinating and doing all the technical aspect of this presentation and make it possible. Thank you very much.